Good evening, everybody. Welcome to White Collar Support Group's Tuesday night speaker series. And tonight, our speaker is Karen Kelly, an attorney from Castellanets, and more about her in a moment. First, I want to tell you a little bit about the White Collar Support Group. We are the world's first support group that supports people who've been prosecuted for white collar crimes and their families. We meet every Monday night at 7 p.m. Eastern. 4 p.m. Pacific. Last night was a Monday night. It was our 525th meeting. So I hope you'll join us next Monday night. Or if you have a family member, friend, colleague, or client who's in need, please have them reach out to us. Our website is prisonist.org. That's prisonist like feminist, prisonist.org. And there's a lot of information there, including when we meet and all kinds of other resources that we have. I have a few announcements before we start. The first is on September 29th, our speaker will be, um, help me here, Greg, our speaker will be Adam Clausen, who went to prison for 20 years. He's back, and he's now a member of the U.S. Sentencing Commission's Advisory Board. And really happy that he's out there advocating for us. So he will be our speaker on September 29th. We will not have a speaker in August. Also want to let everyone out there know that our conference is shaping up. So our online virtual conference is on October 10th. It's a Saturday morning at 9 a.m. Eastern. Our keynote speaker is going to be Josh Smith, the Deputy Commissioner
The BOP.
of the BOP. Thank you, of the Bureau of Prisons. I'm not at home tonight, so I don't have all my notes in front of me. Of the Bureau of Prisons, and he spent some time in prison. And our keynote fireside chat is going to be Dickie Scruggs, who was at one point the wealthiest attorney in the country, and he handled he was the lead counsel for the tobacco litigation successfully, made a lot of money. After that, got into some legal trouble, spent 6 years in prison. He's out now and he's going to tell his story. He's going to be interviewed by our own Brent Cassidy. So I hope everybody will join us for those events. And if you're not on our mailing list, you can sign up on our website, prisons.org. And we'd be happy to put you on the list and send you people. So tonight, our speaker is Karen Kelly. And I'm going to say a little bit about Karen, and then she's going to take over. She has a PowerPoint deck that she's going to share with us too. Just let you know that, well, first let me read this and I'll tell you a little bit about how I know Karen. Karen's the former head of the Justice Department's tax division. She joined Castellanets after more than 30 years of federal and state trial practice, including prosecuting tax and white-collar crime. Her practice at Castellanets focuses on representing clients in state and federal civil tax controversies, defending clients in government investigations, including criminal tax and white-collar matters, and against state and federal criminal charges. Her practice includes conducting internal investigations, representing legal and tax professionals and their firms in license and regulatory matters, and complex civil and criminal litigation. She served as in the Department of Justice as the acting assistant attorney general and delegated component head of the tax division. Basically, she ran the tax division. In that capacity, she supervised all federal, civil, and criminal tax matters assigned to the Justice Department throughout the country. And she had more than 300 trial and appellate attorneys working under her. So I met Karen at a conference maybe about a year and a half ago, 2 years ago, and we've attended a bunch of conferences together, and we've become kind of conference buddies, which was fun. And when it came to trying to find some interesting speakers and interesting topics, I turned to Karen and asked her if she'd be interested in speaking to us specifically about taxes and what the intersection is of criminal tax, civil tax, and how it relates to white collar matters. Because all of us, every one of us, have had tax implications with the things that we've been involved in. So, Karen, really happy to have you. And why don't you take it away?
Okay. So I'm so happy to be here. Thank you guys for having me. I hope that you find my little class interesting and keeps you awake. I will say that I met Jeff a year ago in Georgia at a conference, and I was literally out of the government for, I want to say, 5 days. And I was totally lost walking through this huge mass of fancy lawyers, scratching my head like, oh God, what have I done? And Jeff so kindly and so nicely strolled up to me and started chit-chatting and making me feel so comfortable and so welcome. And then eventually we got to, our different places in the world and what was going on. But he was so lovely. I knew right away. I was like, this is a special person. So that's where we connected. And anyway, I'm so happy that you invited me to be here. All right, on to the excitement of the night, which I say that rolling my eyes because I know not so exciting. Okay, can you see the PowerPoint? Okay, I don't see it. But
yes, we can see it.
All right, well, let's see how that works then. I can get it bigger maybe. Oh.
We see full screen.
It's still on up the screen well, Karen.
Yeah, we could see it, Karen.
Okay, so let me see if I can figure out how to make it move because it's not the same. Okay, there we go. All right. Thank you. Thanks for your indulgence on that. Okay, so we're going to talk about the unique issues about criminal tax in prosecutions, and that touches a little bit on civil as well. But criminal tax is special because it is the way that the United States can catch the bad guy when other charges don't quite fit. I think they use that term weaponization these days, but it's not something that's specifically weaponized, but it's something that's available in the marketplace for capturing unique crimes. And of course, the most famous is Al Capone, right? FBI couldn't prosecute him for his bootlegging operation and his other miscellaneous misconduct, but IRS criminal investigation was able to prosecute him for tax evasion. And ultimately he pled guilty to 5 counts of tax evasion and was sentenced to 11 years in prison, all based on his bootlegging operation. In 1973, Spiro Agnew pled guilty to income tax evasion for filing tax returns that failed to report $29,500 in bribes that he received during his tenure as the governor of Maryland. Tax charges. Everybody knows Leona Helmsley, right? The Queen of Mean. She was convicted after trial of tax evasion, tax conspiracy, filing false tax returns, and mail fraud for her conduct that involved burying her home renovation expenses in the expenses of the hotel business. She was sentenced to 4 years in prison because of her ill health at the time. That sentence was later reduced to 21 months. And you see on her lap is her Maltese named Trouble. And when she died, she willed $12 million to that dog.
Better the dog than Uncle Sam.
Yeah, right. I'm sure Uncle Sam felt differently because ultimately a judge intervened and the dog only got $2 million. So there was also, when the dog got the money, 2 nieces and nephews were disinherited and they brought a lawsuit because they weren't happy either. You know how that is when money's involved. And then Wesley Snipes, of course, famous actor who was prosecuted for tax crimes. Interestingly, he had a jury trial in Florida and was acquitted of tax conspiracy and tax evasion and was found guilty of failing to file his income tax returns, 3 counts of misdemeanor, failing to file his income tax returns. And he was sentenced to 3 consecutive terms of 1 year in prison on those tax counts. Kind of an unusual sentence. Okay, what is it that makes criminal tax cases unique? And we're going to just touch on these things quickly tonight. First and foremost, only IRS criminal investigation can prosecute and investigate tax crimes. So FBI can't bring a tax case, DEA can't bring a tax case, CBP can't bring a tax case. If there's a tax charge, IRS criminal investigation has to be involved in the matter, and that's because of the tax secrecy rules under 6103. Tax crimes are contained in Title 26 of the United States Code. Most of the federal crimes that you're familiar with, wire fraud, mail fraud, are contained in Title 18 of the United States Code. And then Title 26 pertains to taxes. And within Title 26 is the crimes that are the tax crimes of the United States Code. So the difference between tax crimes and other white collar and federal crimes is that there's a multi-level review process that involves both the IRS and the Department of Justice before a charge is authorized for prosecution. And that review process is in place to protect taxpayers because unlike, for example, say narcotic dealers or human traffickers, everybody in the United States is a taxpayer, generally speaking, and involved in the tax system. Not everyone in the United States is involved in illegal narcotics and human trafficking. And so the code and Congress recognizes that taxpayers need to be protected and be treated a little bit differently than the average Title 18 folks. And so there are these different levels of review process in place for taxpayers and tax crimes, just like there's statutory max in tax crimes that are different than similar Title 18 misconduct. As I mentioned earlier, tax information is secret under 6103. So that's a section in Title 26 that limits who can have access to tax information, to your tax information when you file your tax return, or to anybody's tax information. Needless to say, IRS criminal investigation can have access to tax information. FBI can only have access under very specific circumstances to tax information. The law controls that. Unlike other criminal statutory violations, to be convicted of a tax crime, you have to be proven to be willful. And willfulness is the subjective state of mind of a defendant. So it's an intentional violation of a known legal duty. So that's unique to tax crimes, different than, for example, wire fraud or mail fraud. Finally, and we'll talk a little bit about it, restitution under Title 26, restitution in tax cases is a little bit different than restitution that you might encounter into Title 18 crimes. It's not part of the victim witness. It's not part of the Victim Witness Protection Act, and so it's not a mandatory part of the sentence. But typically, your experience is going to be that courts do impose restitution as a condition of supervised release. So as I mentioned, only IRS CI can investigate and prosecute tax crimes. 6103 houses all of the tax information in the Internal Revenue Service and makes it secret. And so that's why those cases all have to start with a special agent from IRS criminal investigation. And there's only a handful of pure tax crimes under Title 26. We have tax evasion, 26 U.S.C. 7201. That's a 5-year felony. Well, that means the maximum penalty is 5 years. We've got filing and aiding and filing in the filing of false income tax returns and false documents with the IRS. That's a 3-year felony. So that means the maximum sentence is 3 years in prison. We have impeding and impairing the IRS, 26 U.S.C. 7212A, the omnibus clause. That's an obstruction clause, and that is a 3-year penalty for violating that. Conspiracy to defraud the IRS, an agreement to defraud the IRS is a 5-year felony. It's a conspiracy with a 5-year cap for punishment. And then the crimes of omission, we've got failure to file, willful failure to file or pay. So willful failure to file an income tax return or pay taxes is a misdemeanor. And so that's punishable by up to 12 months in jail. And then finally, failure to collect, report, and pay over taxes withheld on behalf of another, 26 U.S.C. 7202, is a 5-year punishable felony. So that's the handful of tax crimes under Title 26 that Congress created to specifically address tax misconduct. Okay. IRS CI, they existed since 1919, although the Revenue Act of 1913 created the Internal Revenue Code as we now know it, although very different and has evolved, I'm sure you know, through the years. 1919 is when the intelligence unit was created. Ultimately, they became IRS CI. In 1970, Congress passed the Bank Secrecy Act. And in 1978, the intelligence unit changed its name to what we know to be today, IRS CI. 1986, the Money Laundering Act was passed. And then in 2025, really as of 2026, IRS CI presently employs approximately 2,200 law enforcement officers in IRS criminal investigation. There's a total probably of about 3,000 employees, which includes the administrative support and non-law enforcement. So that's where we are today. Sorry, I'm going backwards and forwards on this. My apologies. Okay, so let's just take a look quickly at the fiscal year 2025 IRS CI snapshot. You can see that in fiscal year 2025, IRS opened 1,380 criminal tax investigations. Of those, 834 prosecutions were recommended in the tax crime universe, and 589 of those tax defendants were sentenced in fiscal year end 2025, which means that those cases were from prior years and went through the referral process, were authorized for prosecution, were indicted in a district court, and either pled guilty or went to trial and made it to their sentencing event within the 2025 fiscal year. Not a huge number when you think about the number of people in the United States. I did a little back of the napkin math on this, sort of conflating tax year 2024 and fiscal year 2025 for IRS CI. So the IRS processed 161 million individual income tax returns in 2024. The IRS collected $5.23 trillion in taxes. The IRS initiated 1,380 criminal tax investigations for fiscal year end 25. So when I did the math on that, the odds of a criminal tax investigation being opened on you, generally speaking, was 1 out of 117,000 tax returns. And just to compare that for purposes of thinking about tax enforcement in the United States, the odds of getting struck by lightning in your 80-year lifetime in the United States is 1 out of 15,000. So if you're selected for a criminal tax investigation, know that you are, in fact, special. Okay. So IRS obviously brings the criminal tax cases, the statutory violations that I've already introduced, but they also work with other law enforcement agencies, the acronyms that you know, FBI, DEA, CBP, and they investigate non-tax financial crimes. And we have a big list there: public corruption, money laundering, illegal alien harboring, cyber crimes, structuring and Bank Secrecy Act violations. Trade fraud is a big new one, and waste, fraud, and abuse is a big focus of this administration. IRS criminal investigation is generally renowned as the federal agency that can follow the money, and that if you have money, you want to have an IRS special agent on the trail of that, because they can really break it down and follow where the money goes. That is their expertise. What IRS criminal investigation doesn't do is they do not conduct tax audits. Okay, that's a civil function in the IRS. They don't collect taxes. That's a civil function in the IRS. They don't focus their cases on individuals who make honest mistakes on their tax returns, because to prove a tax crime, the government has to prove an intentional violation of a known legal duty. So that can't be a mistake or an accident. Okay. And IRS criminal investigation, generally speaking, doesn't answer taxpayers' routine or complex tax questions. Those are all functions of the civil side of the IRS. And the civil side of the IRS is very focused on bringing taxpayers into compliance. That's how they would describe their mission. It's a voluntary tax system. They want to bring all the taxpayers into compliance so that everybody pays their fair share. CI is very focused on deterrence. They want to prosecute individuals who are engaged in intentional violations of the known legal duty and send a strong deterrent message to the community, so that all the taxpayers realize, if I don't pay my fair share and if I engage in an intentional violation of my known legal duty, I may be prosecuted for tax fraud. I may go to jail. So it's a deterrence effort by IRS CI, and that's the unit focuses on that. Very different from what the general IRS focuses on, which is bringing taxpayers into compliance so that everybody pays their fair share. Okay, let's talk a little bit about the criminal tax case, what that looks like and how it's teed up. Okay, the question is, how's a criminal tax case initiated? People ask that all the time. And the answer is, so many ways. There are so many ways that IRS-CI can start a criminal tax case. They start an in-house investigation from something as simple as public sources, newspaper articles. I had a case once where the special agent started his case from the Washington Post article about the top 10 DC employees in their highest salaries. And he simply ran all 10 of those DC employees who were earning the highest salaries in DC to see if they were filing tax returns, and then opened cases on those who were earning these high DC salaries but filed no tax returns. So that's public source information to generate a criminal tax case. Bank Secrecy Act data is probably the primary methodology for giving information to IRS-CI for opening tax cases. That's the currency reports and suspicious activity reports that are filed by banks on transactions that customers may make that are suspicious, more than $5,000, and hit specific boxes of conduct that is suspicious. And the CTRs, as you know, are reports filed regarding amounts of cash and coin that is taken out of a bank account or deposited to a bank account that the banks send to FinCEN. IRS-CI has task forces, and they review this FinCEN data and determine whether there's transactions by individuals and entities that require greater investigation. Another obvious source for starting cases is fraud referrals from within IRS. So perhaps it's an audit where it's clear that there are fraud, that the taxpayers engaged in fraud, and they refer to fraud. And they refer those type of cases over to IRS-CI. They stop the civil investigation and they send it over to IRS-CI for further investigation. The U.S. Attorney's Office is a great source of criminal tax cases. They may have, for example, a healthcare fraud case. And in the course of their investigation into healthcare fraud, they come across information or innuendo that, in fact, not only is the subject engaged in healthcare fraud potentially, but also they're not paying their taxes, or they're engaged in a tax fraud scheme, or they're engaged in a tax shelter. And so they send a referral to IRS and invite IRS to join that investigation. So the U.S. Attorney's Office is a pretty common one. And that happens as well with other federal agencies, all of the regular federal agencies, FBI and DEA, but also SEC and, all of the federal agencies. If they come across in their investigations evidence that their target or subject may be engaged in tax fraud, in addition to whatever it is that they're investigating that subject or target for, they'll invite the IRS in to help with that investigation. And ultimately, the tax charges may be tacked on to whatever that investigation is. And then, as you'd expect, there's always whistleblower tips that come into IRS. And those could be from disgruntled employees and ex-spouses and grouchy neighbors. And I put TV reality series. You remember Richard Hatch? I don't know if anyone even remembers that reality series long ago. I think it was the original. But Richard Hatch, he won $1 million for being the last person on his island. And he was in People magazine, and everybody knew he won $1 million. He held up the check, and he didn't report that income on his tax returns, and ultimately got prosecuted twice, actually, for tax evasion. So there's all types of sources that generate the start of a criminal tax case. Okay, so specifically, how's a criminal tax case initiated? In IRS criminal investigation, there's two ways that they can start their criminal investigation. The first one is the administrative investigation, which is the administrative investigation occurs within the IRS. So there's no AUSA involved. It stays within the IRS. And the special agent conducts his investigation through public sources. He issues summons to get records. He brings on an IRS special enforcement revenue agent to assist to go through the bank records, and conducts an internal administrative investigation. Under 6103, it stays inside the IRS. The other way that an IRS special agent can conduct a tax investigation is to open a grand jury investigation. If he has a reasonable probability that a crime is being committed, he'll take his information. It'll be packaged up in a memo form. It'll go to the Department of Justice, and he will seek authorization to open a grand jury on on tax misconduct with regards to a specific conduct, with regard to a specific individual or entity based on probable cause that there's a crime being committed. The U.S. Attorney's Office can start a criminal tax case. Typically, the way they do that is they have an ongoing grand jury investigation into a subject or target into a non-tax matter. And in the course of that grand jury investigation, they come across some evidence that leads them to believe that there might also be tax misconduct. And in that context, they expand the grand jury investigation to include potential tax charges, and they invite in an IRS special agent to assist the team with their investigation. And finally, DOJ, the criminal division, now the National Fraud Enforcement Division that now houses the criminal tax section, can also initiate grand jury tax investigations. And they do that when they have big projects. For example, they had a big Swiss bank project and John Doe summonses, and they may open grand jury investigations based on information that they obtain through some of their projects and initiatives at DOJ. I'm not going to get this button right, so I'm sorry. I apologize for that. Okay, let's talk a little bit about the steps that unfold in the investigation of tax crimes. So there's non-compulsory sources of evidence that special agents would use when they're investigating criminal tax crimes. And by non-compulsory, I mean there's no subpoenas involved, there's no summonses, there's no court order. Okay, they're just pulling together their investigative materials, assessing whether or not they're going to have a criminal tax case. And this includes interviews. They may interview people, voluntary interviews. They show up at places and identify who they are and ask someone questions about facts and circumstances, what they may have witnessed. They may ask that person who they're voluntarily interviewing for records and documents, and the person says, sure, no problem. Let me give you whatever I have on that, and voluntarily and informally turns over records and documents to the special agent. They conduct surveillance. So that simply means they maybe sit outside a pizza joint and see how many customers come in and out. They may go inside and see how many customers are inside, see how many employees are working in there, see what the inventory is, see what the menu is, just general surveillance. They may swing by the same pizza joint after hours and pull garbage out of the trash to see if there's any invoices, cost of goods sold, books, records, whatever might have been discarded from that business that day, to see if there's any incriminating information or anything that would further their investigative instincts in that regard. And they conduct undercover operations. The last number I had is from 2022. They conducted 401 undercover operations. The most typical undercover operation that I would see is sending in a special agent to have his tax return prepared at a business, an establishment that is suspected to be preparing false tax returns for clients. That's the most common undercover that you would see the IRS engaged in. So the person would go in with a W-2, and the tax return preparer who they're targeting would say, okay, let me prepare your tax return. And the W-2 is handed over, and the tax return that comes back to the special agent in these cases typically doesn't reflect the one W-2 that special agent turned over. They also would do undercover buys, where they would go through the want ads and see advertisements, for example, for a pizza franchise for sale, and they may call up the seller and sit down and meet with them disguised as a potential buyer to learn information about that business and whether or not the person reports their income on the books or off the books, as IRSCI probably suspects. So those are the non-compulsory sources of evidence. Compulsory sources of evidence are those that are required. There's an order of some sort involved. So in the administrative investigation, which is the way that many IRSCI investigations are initiated, the one that stays within the IRS initially with no AUSA involved, in that case, a special agent can issue a summons, which is an order under Internal Revenue Code 7602, and demand records and documents. So in an administrative investigation, special agent might issue a summons to a bank for bank records, might issue a summons to a colleague, to an employer for records that they maintained for payments, maybe to a check casher for records and documents. But in an administrative investigation, when a special agent issues a summons, a third-party summons, the target or subject of those summonses is notified. And so you would receive a notification, hey, Karen Kelly, Bank of America received a summons for your bank records from IRS Special Agent John Smith. And so a summons is something that a target would be made aware of. Also, in an administrative investigation, IRS can use search warrants. And I know you're all familiar with search warrants from TV, where they go in and with a court order that after signing an affidavit and laying out the evidence of probable cause for the judicial official, they can forcibly enter a premise and obtain records and documents that they believe to be on site that are relevant to their investigation. Compulsory sources of evidence in a grand jury are similar. For example, a grand jury subpoena for documents and a grand jury subpoena for witness testimony can be issued by a special agent. But when you have a grand jury investigation, you're going to always have an assistant United States attorney or a main justice trial attorney handling the matter. And in fact, the subpoena will be issued by that AUSA or the trial attorney to get the subpoena, to get the documents pursuant to the subpoena, to get the witness testimony. Witness testimony occurs in front of a grand jury, and it is under oath. And in attendance is the AUSA, the court reporter, the witness, and the grand jurors. If you're a witness in a grand jury, you are not permitted to have an attorney appear in the grand jury with you. You can have an attorney wait for you outside the grand jury. You can interrupt the grand jury and ask for a break to talk to your lawyer, but that attorney cannot come into the grand jury while you're testifying. The grand jury can also issue subpoenas for handwriting exemplars, samples of handwriting. Search warrants are also used and executed during grand jury investigations. And foreign evidence can be obtained, overseas evidence can be obtained in grand jury investigations, something that would be obtained through an MLAT, through agreement with other countries for foreign evidence transfer. So the special agent in the IRS gathers his or her evidence. If it's a grand jury investigation, he works closely with the AUSA. If it's an administrative investigation, he only works within the IRS. And after reviewing and assessing the evidence, the case can be discontinued. If it's an administrative case and it's discontinued in the IRS, it may go back over to the civil side of the house, and perhaps that person instead is audited or there's some other civil action taken. It's entirely possible that the subject or target of that administrative investigation never even knows that there was a criminal administrative investigation opened on them, because it never leaves the IRS and it never becomes public. Or the administrative or grand jury investigation, if the agent thinks the evidence supports prosecution, then the special agent will prepare a special agent report that recommends prosecution. The report summarizes the evidence and attaches all the evidence to the special agent report, and it gets reviewed. It gets reviewed internally within the management chain in IRS-CI, and then it goes to the IRS criminal tax lawyers. They're called CT counsel, who exist to advise and counsel the special agents in IRS-CI. They review the special agent report, they review the exhibits, and they generate a written review. That package of the SAR, the special agent's report, the CT counsel review, goes to the special agent in charge, who reviews the whole package. And if he concurs in the recommendation, that entire package goes over to the Department of Justice for review. It's a prosecution referral. It goes to the Department of Justice. That's a different agency than Treasury. So it goes from Treasury to the United States Department of Justice. Okay. And the package comes from the special agent in charge at IRS-CI, who says, hey, Department of Justice, we have conducted this investigation either as an administrative investigation on our own or with AUSA X, and we would like authorization to prosecute this target, or subject for the following tax crimes. So the criminal tax attorney, who's a specialist in criminal tax in the tax, what used to be the tax division is now the tax section of the National Fraud Enforcement Division, will review that package from IRS. So they'll look at the special agent's report. They will review all of the exhibits that are attached to support the report that lays out all the elements of the crime. They will review the CT counsel package, which is the independent attorneys who've reviewed that package within IRS. And that criminal tax trial attorney will generate his or her own prosecution memo. In that memo, they will agree or disagree that that package supports prosecution of the subject or the target. They will opine on the strength of the evidence. They will identify issues that could interfere with the successful prosecution of that case. They will talk about uniformity to make sure that similarly situated taxpayers are treated similarly. They will talk about the value, the deterrence value of that case in bringing that case, which is typically based on willfulness and the tax loss of the misconduct. And they also assess the overall package to determine that there's a reasonable probability of conviction if this case is authorized and sent to the U.S. Attorney's Office. So the Pross memo is a very fulsome blueprint for prosecution of that matter, and opines heavily on the weight of the evidence and next steps and issues that are presented by the facts and evidence in that case. That prosecution memo is reviewed by the assistant chief in the tax division, who typically has substantial experience in criminal tax prosecution and has seen huge volumes of cases that have come through the tax division in the Department of Justice. The assistant chief generates a review note, so a high-level perspective of that case and the evidence and the issues and what footfalls the AUSA needs to be aware of in bringing that case in a district court in the United States. And then that whole package goes to a chief who reviews the entire package and generates what's called an action sheet, which is the final action. Yes, this is authorized for prosecution. No, this case is not authorized for prosecution. We're sending it back to IRS for additional work. Or some of these charges are authorized, some of these are not authorized. Or this package is authorized with discretion to the U.S. Attorney's Office to bring this case if they have the resources to do so. And that whole package is sent to the U.S. Attorney's Office for prosecution. Okay. When the U.S. Attorney's Office gets that package, they get a letter that says, the tax division has reviewed this matter from the IRS that has been referred. You're authorized to prosecute specific defendant for the following charges for the following tax years. And that's a mandate, so that AUSA goes forth and indicts that case, or they ask for a tax division attorney to come out to their district and handle that matter for them. Okay, so that's the process. That's the sausage making of the tax case. And the important thing to think about with regards to the sausage making of a tax case is there's multi-levels of review in two different agencies before that case goes to the U.S. Attorney's Office for prosecution, and has another level of review when it lands on an assistant United States attorney's desk, who then reviews the entire package for viability, because they're the ones who have to indict it and who have to present it to a judge and a jury in their district. Okay, so there's a lot of levels of review, substantially more than, for example, if a case was brought, a non-tax case was brought by FBI, the FBI agent puts together his investigative package, and then he goes to the U.S. Attorney's Office and talks to an AUSA about what he has. And then they move forward with additional investigative steps as needed before indictment. So that's a pretty significant distinction and a number of protections in place for taxpayers through the tax section. Okay, my next slide moves us pretty quickly into what makes a tax case, tax charge, different from non-tax charges, and that's the element of willfulness. So to prove a criminal tax case, to prove that somebody engaged in a criminal tax violation, the prosecutor has to prove to the jury and to the judge that the taxpayer, defendant, engaged in an intentional violation of a known legal duty. That's generally the standard. That's the element for all of the tax crimes, an intentional violation of a known legal duty. And that's a very subjective state of mind. Short of a lobotomy, it's very hard to know what's inside a person's head. Very, very difficult, challenging standard. And it's a subjective standard, meaning that the defendant is not required to have been objectively reasonable in his or her misunderstanding or understanding of the law. So it's subjective, what's inside the person's head. And that requires marshaling facts and subjective circumstantial evidence, really, to try to prove to a judge or a jury what is inside that taxpayer's head, such that it's an intentional violation of a known legal duty. And so prosecutors try to marshal the facts, and they look to conduct to prove what's in the defendant's head. So they look failure to supply the accountant with accurate and complete information. They will call the accountant in and say, did you know that Johnny had a sole proprietorship Schedule C business where he was selling stickers and was earning income? And the accountant will say, no, he never mentioned to me that he had outside business. I thought he was a W-2 wage earner. That's why that's only a W-2 income on his tax return. The prosecutor will point to the background, education, and experience of the taxpayer. You'll see a prosecutor arguing that this person has an advanced degree. They have a master's in business. They're successfully running their own business. They're an entrepreneur who've opened this business. They're savvy, financially smart. Of course, they knew their legal duty. Prosecutors will point to false statements to agents, misstatements, false exculpatory statements. They will point to false documents, entries, invoices, keeping a double set of books, hiding, destroying, or losing books that are relevant to the conduct. Willfulness is generally proven by placing property, bank accounts, businesses in nominee names. So businesses in the name of your dog or cat, your house named in the name of your deceased mother-in-law. Your businesses are held in nominee bank accounts, nominee names, not real corporate business structures. They'll point to previously reported income of the same type or a consistent pattern of underreporting. So, in prior years, the defendant reported Schedule C income, and then it suddenly dropped off the tax returns. They'll point to that to say, obviously, the taxpayer knew that it needed to be reported. Prior FBARs filed for foreign bank accounts, suddenly no FBARs for the foreign bank accounts. Obviously, the taxpayer knew that they needed to do that and stopped doing it. They'll also point to expenditure evidence. They'll argue instead of paying the taxes that were due and owing, this defendant was paying for their country club, for their private schools, for their second home, for their fancy car. Whatever they can find, they will argue to the judge and jury that expenditure evidence shows willfulness, shows the intentional violation of the known legal duty. They'll also point to the receipt of notices from the IRS that the taxpayer was aware of their known legal duty because they received correspondence from the IRS. The letters the IRS sends you, hey, you haven't filed a tax return yet for 2025, please do so, the law requires it. Or, hey, you owe X amount of money in taxes, please pay so that we don't have to take the next steps of trying to collect it. Those type of letters, that type of correspondence, those type of notices, the government will gather and point to say, look, Your Honor, this is an intentional violation of a known legal duty. This person knew exactly what was expected of them, and they didn't do it. The government loves to show the jury lifestyle evidence. And of course, this is a picture of what do we call that? A cigar boat, a fast, expensive boat. And if the taxpayer has a fast, expensive boat, instead of paying their taxes, you can be sure that the prosecution is going to put that up on a screen for the jury to see. Okay. Just quickly, I'm going to touch on 26 USC 6103. I mentioned earlier that tax is secret. Only IRS CI and the IRS has access to our tax returns under the law, under 6103. And prosecutors and investigators have to treat your tax information confidential. That means that disclosure is prohibited except for very specific circumstances. So the prosecutor can disclose your tax information in court, in district court, and they do that by filing an indictment or filing an information. And you'll see in tax cases, they're very loquacious. The indictment and information has a lot of words and explains the scheme very thoroughly and includes a tax amount. A lot of that is because they're trying to get the tax information into the public record, because it's prohibited to simply disclose tax information. You can't just walk around as a prosecutor and talk about someone's tax returns and what the tax returns say. That's a violation of 6103. Tax information becomes public when it's disclosed in a court. So when it's in a public indictment, when it's in a filed plea agreement, when it's in court filings, when it's in pretrial motions, motions in limine, trial exhibits, trial testimony, sentencing memos, attachments to sentencing memos, any type of exhibit filed in the United States District Court makes that tax information public and makes it available to be in the public record and in press releases, for example, which is where it would impact you the most. Okay. So let me just touch on some of the defenses that you might encounter in a criminal tax case. Obviously, to be found guilty of something where the state of mind is an intentional violation of a known legal duty, uncertainty in law would be a strong defense against a criminal tax case, because you have to be guilty of violating a known legal duty. And if the legal duty is unclear or uncertain, then you can't be willfully violating it. And an unclear, uncertain duty would be a tax area that is murky, that there are experts who, have differing opinions on how a certain provision or regulation or tax section would be applied. So if it's not clear and the tax experts don't know how it properly is applied or can't give you clear advice, certainly a taxpayer can't be held to a standard that would impose a criminal violation on them. It can't be a known legal duty, right? So uncertainty in law is a strong defense against a tax charge. Good faith is simply the other side of the willfulness. So willfulness is an intentional violation of a known legal duty, and good faith is I didn't intentionally violate a known legal duty. I acted in good faith. I believed what I was doing was legal. I understood I was complying with the law based on my understanding of what the tax law required. I had no idea that I was somehow running afoul of the tax statutes. So I acted in good faith. I provided all the records. I was, to my mind, abiding by my tax obligations. So good faith is a common defense to tax crimes. Mistake, negligence, and ignorance. So in most crime, mistake, negligence, and ignorance are not sufficient excuses to not be found guilty of that crime. But in tax cases, if you made a mistake, or if you're negligent, or you're just don't know the law and don't understand the law, ignorant, then you can be acquitted of tax crimes, because again, the state of mind is an intentional violation of a known legal duty. So just quick, for example, if I was to go through the TSA screening and I had a gun on my hip at DCA in DC, they would take me on the other side and throw me up against the magnometer and say, "Lady, you're going to jail." And I'd say, it's a mistake. I didn't know I had a gun on my hip. Still guilty. I was careless. I forgot that I had my gun on my hip when I came to the airport. Still guilty. I had no idea that it's illegal to have a gun on my hip when I go to the airport. Still guilty. Okay, so it doesn't matter, any of those excuses. I'm still going to jail because I had a gun on my hip when I went through the TSA screening. Very different in a tax case, Your tax return is false, Miss Kelly. I had no idea that I had to report that information on some schedule that attached to my tax return. I had no way of knowing that, and I didn't know it. Or I'm extremely careless and not careful in the matters, and I'm negligent and careless and reckless, and I had no idea. Or ignorance. It's never crossed my mind that I had to file a tax return. I had no idea. This is new to me. I'm not a person who is of any knowledge, and I simply didn't know that. These are the types of things, arguments that would be better crafted than the ones I just gave you, but an example of the contrast to going through the TSA with a gun on your hip. Okay? Another example of a common defense that you'd find in tax cases is that there's no tax loss. So one of the elements you have to prove beyond a reasonable doubt for tax evasion is that there's a tax loss. You have to prove, the government has to prove a tax loss beyond reasonable doubt. And so, of course, the taxpayer and his attorney is going to attack the tax loss, bring that number down, or eliminate it altogether, or say that it's immaterial, that this is not a material tax loss, and thus the elements don't stand. Finally, one of the more common defenses you see in a criminal tax case is reliance on professionals, where you have an accountant or an attorney and the taxpayer consulted with the accountant or the attorney in good faith, provided their records and documents, and followed their advice. In those cases where the evidence supports that the taxpayer did rely on a professional in good faith, that's a pretty ironclad defense against being convicted for criminal tax misconduct. Okay, I'm just going to jump to sentencing and some sentencing issues that come up in criminal tax cases. Like all federal crimes, the sentencing process is controlled by the United States sentencing guidelines, which are now advisory, and Title 18 USC 3553, what we call the 3553 factors. This is the two-step process that a United States District Court judge uses when they're fashioning a sentence in a federal case. In a criminal tax case, the sentencing guidelines that pertain are in Chapter 2, Part T for tax. And the sentencing is based on the tax loss caused or intended to be caused by the taxpayer. So it's a number-based assessment in the United States sentencing guidelines. When they can't come up with a number for purposes of the guidelines, they take calculations based on 28% of the unreported gross income. So this is the United States guideline truncated tax table, which is in the United States guideline Chapter 2T. And you do a calculation, for example, a tax loss of more than 100,000 starts at an offense level of 16. And then if you're familiar with how the sentencing guidelines work, there's enhancements for conduct, and there are points that are subtracted from the number for acceptance of responsibility and for not having a prior criminal conviction and other matters. And you come out with a guideline range that is advisory and that the court considers when they're trying to fashion a sentence. And the guideline range is supposed to be consistent with similarly situated defendants with a similar tax loss. It's supposed to reflect that, so that there's some uniformity based on tax loss in sentencing. In addition to that computation, that advisory guideline computation, the court also is required to look at Section 3553. And that says the court should impose a sentence sufficient but not greater than necessary to comply with the purposes of sentencing. Well, what are those purposes of sentencing, you ask? The nature and circumstance of the offense, to promote respect for the law and to promote just punishment for the offense, to afford adequate deterrence to criminal conduct, to protect the public from further crimes from this defendant, and to provide the defendant with needed educational, vocational training, medical care, or other correctional treatment in the most effective manner. So that's a calculus, a formula that the sentencing court is supposed to follow when they're crafting a sentence for an offender. And of course, as you know, they also have input from the probation office in the form of the pre-sentence report that intimately lays out the details of the offender and of the characteristics of the offense. Restitution in criminal tax cases is interesting because, as I mentioned, criminal tax charges, Title 26, is not included in the Victim Witness Protection Act, which means that restitution is not a mandatory part of a sentence in a criminal tax case. And I suspect that that's because the IRS has an entire thousands of employees whose only job is to collect taxes from taxpayers. And perhaps Congress, when they were drafting the VWPA, thought IRS doesn't need any help collecting the taxes that taxpayers owe. In any event, just because it's not mandatory doesn't mean that tax cases don't have restitution. You'll see more often than not, the courts do impose restitution, and assistant United States attorneys require it in the context of their plea agreements. A court can order tax restitution as a condition of probation or condition of supervised release as part of a sentence. And after trial, a court can order restitution as a condition of supervised release or a condition of probation only for the counts of conviction. And what you need to know is that restitution that's ordered as a condition of supervised release is only collectible during that period of supervision. And for tax crimes, the maximum period of supervised release is 3 years. The other thing you want to know is that the restitution numbers are always going to be different from the tax loss numbers, because the restitution numbers are actually the amount of money that the taxpayer owes to the IRS. Restitution to the IRS. The tax loss numbers include intended tax loss and can include relevant conduct from other tax matters from prior years that are out of statute or other tax conduct. So the tax loss number typically is going to be larger than the restitution number in most tax cases. In most circumstances, the restitution number in a criminal case doesn't compromise or settle a taxpayer's civil tax liability. But understand that the IRS can only collect the tax that you owe for a period from one time. They can't double dip, right? They can't just keep getting money from you. They can only get the tax due and owing for the period that you owe it. And once that's paid, that's done. Whether it's paid civilly or paid through criminal restitution, that's done. The IRS cannot double dip. You'll receive credit for any amount paid towards that debt. And restitution can, if the AUSA chooses to do so, can include interest through the date of sentencing. So the number can get big fast. And on the civil side, of course, any amount of taxes that you owe include interest and penalties. And sometimes that can be rolled in for purposes of restitution or tax loss in a tax case, depending on the charge. Okay. You need to know that in a plea agreement, parties can agree to any terms because it's a contract between the United States and a defendant, and that includes the payment of restitution to the IRS. So in a plea agreement, you can agree to pay more restitution than what the charges are, well beyond the years, or whatever the two parties agree to. Finally, if restitution to the IRS is agreed to in a plea agreement, it is an independent part of the sentence and is enforceable for a much longer period of time than the restitution that's ordered solely as a condition of supervised release or probation. It becomes an independent part of the sentence, and that allows for restitution-based assessments, allows for IRS to collect it as if it's a tax, and so they can use all their tools in their toolbox as if they were collecting money in any civil tax matter, and their toolbox is pretty deep. Okay, that's my little lesson on criminal tax to keep you awake on a Tuesday night at 8:08. So I hope you found that to be informative and not too traumatic.
Karen, thank you so much. I love that, but I love technical presentations. So thank you so much. If anyone would like to ask Karen a question, please put your name in chat and I will call on you. But Karen, I'm going to ask the first question.
Sure.
Given that criminal tax matters are so infrequent.
Yeah.
What are there specific places that are more likely than not that that would be investigated? I mean, for example, are you more likely to be investigated if you file Schedule Cs than separate sub S tax returns, things like that?
So those type of metrics are probably used for civil audits. They run different initiatives. Those aren't the type of metrics that they use for criminal investigations. From administration to administration, the priorities change. And so they run criminal initiatives based on what the priorities are of each administration. So the present administration's priorities include waste, fraud, and abuse. So right now, you'll see there's a lot of cases involving PPP fraud and EIDL loans and Medicaid and Medicare fraud and any kind of fraud on the government. and tax crimes are enmeshed within that. So you'll see those types of hybrids. You'll also see Title VIII is a priority in this administration. So that's immigration crimes. So you may see tax crimes enmeshed in immigration fraud. So you may find payroll tax violations where somebody's not paying over the withholding tax, or maybe they're paying employees under the table. And you may also find with that a harboring illegal alien charges, Title VIII violations, or some type of Title VIII violations. There, in prior administrations, they've had initiatives involving offshore tax and FBARs. Right now, this administration has a number of different priorities. They do involve tax, but there's not a checklist where they say if you are an S corp and you file 1120S, we're going to look at you. They did have an initiative, for example, that was called the High Net Worth Non-Filing Initiative. And so that's a simple initiative. If you're making over X amount of $1 million and your transcript shows you're not filing tax returns, okay, well, that's a good place to start, right? You've got huge amounts of money that are being reported to the IRS on the third-party transcripts, and the other transcripts the IRS has says you're not filing tax returns. That's easy to marry that case up, and that was an initiative trying to bring in more money for the fisc. But so they run programs and initiatives, and so on the criminal side, there isn't really a where I could say, oh, don't do this, do this. I can say that for a case to be a criminal case, they want the case to be one that brings a message of deterrence to taxpayers. And to my mind, the way you deter taxpayers is by putting the wrongdoer in jail. That's what makes the other taxpayers sort of sit up and take note and go, oh, snap, the chiropractor for my country club just went to jail for tax fraud. I better call my accountant and make sure my affairs are in order. And so I think they're mindful that the tax loss has to be sufficient, that under the sentencing guidelines, a prison sentence would be warranted, unless the conduct is, not is unique in its own way. The target is unique or something very unique.
Thank you, Karen. All right, we're going to open it up. First is Linda and then Alex. And if you'd like to ask Karen a question, please put your name in chat and I will call on you. Go ahead, Linda.
There we go. Hi, Karen. This was exactly my case. It was a
I'm sorry.
Well, it was a payroll case. I did not own the company. I could sign on the records, and the owner of the company was my sister. Okay, so we end up in Danbury together at camp, which was not a bonding experience. Okay, my problem is joint and several restitution on her tax debt. Okay, it was her company, it was her payroll tax, and now I am 3 years down the road, and she is doing everything she can to dip into my assets to pay her tax debt, because at the end she'll sell her vet practice, which is a veterinarian practice, and that will be less money that will come off what was her tax debt. The restitution and her tax debt are identical. The judge ordered no penalties and interest, so she actually came out of this. The whole crux of the matter was that there were problems. We were trying to fix the problems, and in the process of honestly dealing with a whole lot of bureaucrats, everybody kind of lied. We were trying to set up a payment plan. My question is there a way that I can fix my restitution based on fairness? Everything I have in life is tied up in a tax debt with somebody, with a company I don't control, and that I can't, with a person that I don't get along with, to put it mildly.
Yeah, that's a terrible situation. And joint and several means that, as I said, the IRS can only collect that debt one time, but joint and several means they can collect it from you or her.
Correct.
So you're both on the hook 50%, or you're both on the hook 100%. Actually,
100%.
You could pay
right.
the whole thing, and then you would be able to be completely off the hook if she paid the whole thing.
Well, her scheme is real simple. I understand joint several. Her scheme is anything that I have coming my way, and of course I have properties I can't sell or anything else, it would go to her tax debt.
Right.
is to
Yeah,
get as much
terrible.
of my assets to pay her debt. And then when she sells the vet clinic, she'll have, it'll be so much money more in her pocket. I'm trying to revisit this with the courts, and I'm asking you, is there a vehicle to do that?
So a restitution order is a final order, so that's very challenging. I don't want to be giving you legal advice
I
sort of
realize that.
over the video and all. Puts me in a tricky spot too. So
Karen, can people reach out to you
yeah,
individually?
we can just chit chat offline.
That'd be wonderful.
But it is a very difficult position that you're in, and those are final orders. The IRS has to collect it from you and your sister, and they will take steps to do that. I suppose you were probably pretty happy to hear that so many people left the IRS over the last 2 years. That's fewer people to collect the money that your sister owes them. But it's a terrible situation.
Okay. Yeah. If I can have your contact information, that would be great.
Yeah, Jeff has all that.
Thank you,
Alex, and then Sean.
Yeah. A super fascinating presentation. Thank you very much. I'm actually glad that I never crossed with that department any lines. Yeah. I just have one question, and that was a little puzzling, but maybe I misunderstood. So I think when you open an investigation, not you, but when the unit opens an investigation, they can open a criminal investigation in the first place only, for example, targeting the 10 highest earners? Not knowing that, because I'm surprised that they start out with a criminal investigation and not simply check, whether they pay their taxes or not.
Yeah, no, so what I was saying was the information, all this public information is available, and they would check that. So in this case, for example, you would have an article saying these are the 10 highest earners, and then the special agent looks at that and sees, oh, all 9 of them have filed tax returns, but this one person who makes X amount of money hasn't filed any tax returns. Let me look a little bit more carefully at that. And then they would be able to look at the IRS database and see, well, was there income reported for this person by third parties, W-2s, 1099, third-party reporting system. And they would be able to pull that information together and start to put together a little theory like, looks like this person earned X amount of money in the past 5 years and hasn't filed any income tax returns. This looks like this could be potentially a good case. Let me number this collection of information. So it's not a target or a subject yet. It's a collection of evidence at that point. Let me number this and look at some more information and see if this person or this case is worthy of pursuit. And so it starts off, the point is that the investigation gets numbered and starts off as something in the public. It's Richard Hatch on TV winning $1 million and going, in People magazine announcing he won $1 million, and a special agent saying, geez, that's a lot of money. I'm sure he filed taxes on that. And then looking at the IRS database saying, wow, Richard Hatch or whomever, whoever the person may be, hasn't filed a tax return perhaps. And that's the start of the process. Then they number that information and it goes through a number of levels before it becomes a case. And then when it reaches a certain level, it becomes a case in the administrative section of the IRS. And then they start making third-party contacts, getting evidence and information. But even after they get evidence and information, they can discontinue that case saying this isn't a worthwhile use of government resources. This is, even if I worked this case all the way to the end, this isn't a worthy case to bring to a United States District Court. The tax loss is too low. The evidence of willfulness is too weak. The person is perhaps uneducated and clearly had no idea they had to report these taxes. So it's kind of an organic process when you get down to it. Okay. But it can start from public source information like a newspaper. It can start from a whistleblower calling up saying X, Y, and Z is cheating on their taxes and here are the records. Let me send them to you.
Okay. Interesting. Thank you.
Just a little disconcerting, right?
Yeah. I mean,
yeah.
But I guess the person has no idea, right?
Well, the
Thank
special
you.
agent does, right? Because they can start to
No,
actually.
I mean, but the person who
Yeah,
is
right?
investigated has no clue that there's a criminal investigation going on.
Yes, initially the target, the person who ultimately becomes a target, has no idea. Very unpleasant.
Mm. Thank you.
Thank you, Alex. Next is Sean, then Nancy, then Lucky, and we'll wrap it up so we can be off by 8:30.
Hey, Karen, that was great. I totally was
Oh,
looking
good.
forward to your talk. As a former CPA and still an EA, I find this stuff so fascinating. My question is, with the budget cuts at the IRS, is that trickling? I know it's on the civil side. You see a lot less audits and a lot less revenue officers. Is that trickling to the criminal side as well? Is that why the criminal case number is so low of only like 400 something?
So the criminal case investigations was more than 1,000. The sentencing number was 500.
Okay.
But also there was a whole nother column of non-tax but financial crimes like money laundering, for example, Bank Secrecy Act violations that IRSCI does do as well. So I was mostly focusing on the pure tax side of it. And I think that IRSCI, their numbers are relatively strong comparatively, like if you were to look over the last decade. So they're not, I don't think, the lowest they've ever been, but a portion of them have been siphoned off to do different administration priorities. I think they're back now doing IRSCI work, but for example, they were doing border work for a period of time and doing some other administration priorities. Certainly that impacts the generation of cases. And then importantly, the U.S. Department of Justice has experienced an enormous amount of attrition. And those AUSAs and tax division trial attorneys are the experts who take the case from the agent and bring that case to the grand jury, get an indictment, negotiate a plea agreement, or take it to trial in the district courts. These are complex trials. So that requires a level of expertise in the U.S. attorney's offices.
Mhm.
And it requires a substantial amount of time and commitment by an AUSA. And again, with administration priorities being what they are, I think that with the smaller number of AUSAs and them being really strained with administration priority cases, I think there is a challenge. I think that there's a challenge right now.
Okay, thank you. Again, great presentation.
Oh, well, thank you.
Thank you, Sean. Nancy, and then Lucky.
I have kind of a backwards question. It's I had a money laundering case that was built on EPA grants. So we had approximately $4 million in EPA grants sent to us with 4 defendants, or four of us that were involved. I got a call from IRS and they said, you have to claim that whole $4 million as income to me. So if they did that to me, they're still doing it to my co-defendants. So now the IRS is trying to collect monies that was given out for $4 million from 4 people. So isn't that the IRS triple dipping or quadruple dipping to their tax liability from my co-defendants and myself?
So without really commenting on your specific case and giving you legal advice, I think
Right.
if they were saying that that was a distribution to you,
Yep.
right, that you got $4 million in income,
Yep.
if each person got $4 million in income,
Mhm.
is that what it is? Was it $12 million?
That's correct. Well, I had to pay taxes on $4
16
million.
So it was a conspiracy?
It was, I believe, yes, I think that was considered a conspiracy because there are 4 co-defendants in it.
And they
And so-
attributed it to you as income, the $4 million. It's
That's
a
correct.
distribution. Yeah.
That's correct.
hmm
And so I have to assume, because I don't know, and I'm not going to contact those co-defendants to see if they got the same information. I mean, I had to pay, I have a tax bill of $1.7 million now
Sure.
because
Yeah.
of that 4 million. So it's like, holy crap, not that they'll ever see it or that I can ever pay it.
Right. No. So that's not restitution really so much as they're
No,
taking that credit and they're attributing it to you as income. And so they're
taking
saying
that-
that's
right,
income to you.
They're taking what I'm paying restitution on right now, the $4 million, and they're taxing me on that $4 million. So now I not only owe the $4 million, but also 1.7 million on that restitution.
Oof.
Yeah.
Oof.
Not that they'll ever get it, but I mean, they're taking restitution from my Social Security, and the IRS agent said it should disappear in 10 years, but I've still got another 5 years to go. So it's just
that's brutal.
it's like a cluster, and is the IRS triple dipping or double or quadrupling on taxable income from my co-defendants and me?
Yeah, they shouldn't be. They can only collect a tax debt one time, and credit is made to that debt regardless of who it comes from or where it comes from. Right? They're not in the business of making money. They're in the business of collecting taxes.
Well, it sounds like to me, since I'm paying on the $4 million, that everybody else is also paying on the $4 million, but I don't know if IRS, and of course they won't tell me if they did that too or not. So it's a horrible quandary, and it's like, holy crap, there's nothing I can do about it. I mean, you're screwed. But it sounds like the IRS is, like I said, quadrupling. And what do I do about it? What can I do about it? Nothing, I don't think.
Yeah, I think I would probably reach out back to my attorney, whoever handled that, because you want to make sure,
It was the IRS agent that called me and said, this is what you need to do, and just sign the papers and get them to me, because you only have 10 years to collect it and get it gone. So I know it's this. Where do you go? And this is 6 years ago.
So was that part of a plea agreement that the IRS gave you that paperwork?
No, I got out of prison, and then the IRS contacted me and said, this is what we're doing.
So Karen, what you're hearing is part of the fatigue that sets in.
Yeah, that sounds like that's a civil agent who reached out to you saying that there's a restitution number and we want to collect it from you. Sign this paperwork. So that's different than the criminal side of the case. It's the civil side. So once they put the restitution-based assessment on the books, once it's set up in that way, so you pled guilty and agreed to restitution?
I had to, yes. My attorney said to, yes.
So once that's in the books as a restitution-based assessment, then the IRS, the rest of the non-criminal side, can collect it like a regular tax, like no different than any other tax. And they can use all their tools in their toolbox to do that. And as you probably know at this point, the IRS has a lot of tools on the civil side to collect those outstanding taxes.
Right. Well,
yeah. And so that's what's happening to you.
But
so that's the civil side.
But
yeah,
Nancy,
they moved it to the civil side, and it's a restitution-based assessment.
But Nancy, because it's a restitution-based assessment, that 10 years may not be accurate. So you should speak to someone about that. Okay.
Okay.
I'm saying may not be. I'm not giving you legal advice, but it may not be
and
accurate.
I understand that. The IRS agent said that the IRS only has 10 years. So from this date, as soon as they got it and accepted it, they only had 10 years to get it, and that was it. So she just signed the damn thing and get it to me. And I'm like, okay, fine, I'll just do it, get it off.
Put it in the chat GPT. Put it in the chat GPT. It'll give you an answer.
Wouldn't be the first IRS agent that lied.
Restitution-based assessment. What's the statute on?
Sorry.
Okay, yeah, I'll go check that. See if I can't find that. Thank you.
All right, thank you, Nancy. Next is Lucky, and then we'll wrap it up. Lucky, you're on mute.
Hi, Karen. My name is Lucky Odd. I actually just sent you a LinkedIn contact. One thing I like hearing, thank you for the presentation. I liked hearing a bit about willfulness, because I had an anti-kickback healthcare charge I was acquitted on last October. And one of the big things in these healthcare fraud cases is willfulness. And
knowledge. Yeah.
It's very frustrating to hear all of this, hear so many of these doctors that say, I had no idea, this was not willful at all. But that, however, is a proper defense. But it's not necessarily proven. It seems like you guys have a higher bar to prove willfulness before you bring a case for criminal. Can you tell me anything about kind of what your bar is there, or how maybe I could take that to be a little impactful on the other side with the things I'm working on? Is that element of willfulness is so key, but people's lives are destroyed before they get to.
Yeah, well, take a look at that cheat case that I put in the PowerPoint. I don't know if you guys get the PowerPoint. I can send you the cheat case. That's sort of the seminal case on willfulness in tax cases. And it basically talks about the fact that it's a subjective state of mind. And it's really like what's inside the defendant's head. And that is a pretty powerful highest level of burden of mens rea in a criminal case. Right?
Correct. I think that's what we're missing a lot is the mens rea. You actually have to have intent to defraud.
100%. You've got to have intent to commit tax fraud.
Okay.
Now, there's case law that says, well, you can also be, trying to hide your assets from your wife, but that doesn't mean you're not trying to hide them from the IRS kind of stuff, saying, you can't just say like, I just didn't want my wife to know about my assets and get away with it. There's a lot of activity that the courts will infer as circumstantial evidence that proves mens rea and willfulness, but it's a high state of mind. And a lot of times in criminal tax cases, to disprove willfulness, you have to, a jury wants to hear from a defendant, like tell me what's in your mind, right? The defendant saying, I had no idea. That's one way to meet that very high, to rebut that very high state of mind is have the defendant take the stand and say, look, I had no idea. This is shocking to me.
Thank you. Yeah, that's one of the things that I was told is that I would need to take the stand, and that's one thing that he encouraged. So, okay. Well, thank you very much.
That?
Unfortunately, I didn't have to. The prosecution made our case for us.
Oh, good.
They
Okay.
didn't have enough evidence. So
that's good.
Lucky. Thank you.
Thank you.
And Karen Kelly, thank you so much for being our speaker tonight. It was a fantastic presentation, great Q&A. If you want to reach Karen, Karen, what's your email?
It's Kelly, Kelly at Kostelanetz, KOSTELANETZ.com.
If you want to know how to spell Kostelanetz, they will be a sponsor at White Collar Conference 2026. So you're going to be seeing their name a lot.
Yeah.
Again, if you'd like to know more about our support group, please find us at prisonist.org. That's prisonist like feminist, prisonist.org. Karen Kelly, thank you so much for being our speaker tonight. Blessings to everyone, and we will see you next time.
Nice meeting you all. Have a great night, everyone. Take care.
Good night.